Approximately 1 in 5 women will be sexually assaulted or raped between the time when they're dropped off at school to start as a freshman and when they complete their collegiate career. It's a staggering number that nobody wants to talk about. Between 80 and 95% of women who are the victims of sexual assaults or rape when they're at school on college campuses don't report it. Our young women need to feel comfortable coming out of the shadows to talk about these sort of things when they happen. Frankly, the attackers, people that are perpetrating this sort of activity, and the colleges and universities that enable them, that should be cowering in fear. The fact is, the laws are there that can help address the sort of situation where a young college student has been sexually assaulted or raped on campus. There's a federal law called Title IX, which imposes a duty on universities to have systems, policies, procedures in place to help prevent sexual assaults and rapes from occurring on campus, and which imposes a duty on those schools that when those sort of incidents do occur, that they respond immediately, effectively, and appropriately in addressing the situation. So for example, there have been instances where a college or university was on notice that a male student had acted inappropriately toward a female some point earlier in his career, and then later he takes advantage of a woman a year or two down the line, and there's a sexual assault or rape allegation. Well, the university didn't do its job in addressing the first situation, and it can be civilly liable under Title IX for the harms and losses that this young woman has now suffered as a result of its negligence. Also though, even in situations where a university wasn't on prior notice that a particular male employee was dangerous, this university can still be liable for a sexual assault or rape incident where they don't respond effectively and immediately when they learn of the incident. So there are a long list of tales of where universities and colleges have not responded or not investigated thoroughly enough allegations against some of its male students. And in those scenarios as well, the universities and colleges can be held responsible for the underlying incident. Title IX only applies to universities and colleges that receive federal funding, but the overwhelming majority of universities and colleges, certainly the larger ones, do receive some sort of federal funding and are governed by Title IX. There are 2 causes of action available under North Carolina law. There's a tort called battery, which is basically an unwelcome physical touching, and then there's another tort called the intentional infliction of emotional distress, both of which would fit very neatly and address situations where a woman's been sexually assaulted or raped. We want to help. A sexual assault or rape is more than an attack on the body, it's an attack on the soul. And the fact that this is happening so prodigiously and that nothing's being done about it is just morally reprehensible. We see opportunities to help women that come forward and want our help under both federal law and North Carolina law. We're offering free consultations to female college students that have been sexually assaulted or raped. I think it's important at the very least that they learn about what remedies they might have under civil law to address what happened. Obviously, it wasn't that long ago, or actually it was long ago. When I was a college student, and we didn't have money to buy pizza, let alone, fund a lawsuit against a university or a male student. That's not a problem. Our firm certainly has the resources to help cover expenses, even if our client who might be a college student can't afford that. There are 3 misconceptions that I think prevent women from coming forward when they've been sexually assaulted or raped. The first is, a misconception that, but I knew my attacker. He invited me to this party, or he invited me to his apartment. That's common. In fact, 90% of sexual assaults or rapes occur, the rapists or attackers are people that the victim knew. So that doesn't mean that you can't have viable legal claims against the university or that individual. A second misconception is that, well, what if I was drinking? I was under the influence of alcohol when it happened. Will I be believed? Does that mean that I can't recover? Again, that's very common. 9 out of 10 situations of sexual assault or rape involve the consumption of alcohol, and in fact, many times, the woman is incapacitated by alcohol when the attack occurs. Again, it's common, and that doesn't operate as a bar to pursue any of the legal claims that are available. And then finally, the third misconception is that, by coming forward and hiring a civil attorney, that this is going to be all over the newspapers, or there need to be public court filings. And that's not necessarily the case. The reality is that colleges and universities are under immense pressure to settle these cases when this sort of thing happens. So it's important for survivors of rape or sexual assaults to understand that, coming forward doesn't necessarily mean you have to come out.